So good morning to everyone. Esther Huerta speaking from the Africa IP SME Helpdesk that is based in the UIPO in Alicante. Thanks a lot for joining this session. Today, I would like to present to you the webinar on protecting your intellectual property rights in Kenya. Let me give you a few tips in Zoom before starting. I know that you may be already familiar with Zoom, but just to inform you that you will have a series of presentations. During those presentations, we invite you to mute your microphones. Of course, we want to hear your voice. We want to hear you. So please, you can write your questions in the chat during the presentations. And once the presentations are finished, we invite you to raise your hand and we will give you the floor to actually ask all the questions that you have. Our wish after this session is that you know more on how to acquire trademark measures in the Kenyan market and how to prevent counterfeit goods from entering the local market, among many other things that will be explained by our experts. But first, let me give you a little bit more information about us, which is the Africa IP SME Helpdesk. The helpdesk is, this helpdesk, the African one, is the latest of a series of initiatives of the European Commission, but this time it is implemented under the EIPO, the European Union Intellectual Property Office based in Alicante, and more specifically under the AFRIP project, which is a project that aims to increase effectively the level of protection and enforcement of intellectual property rights in Africa. The helpdesk is a free of charge service that can help you get more information on how to best protect your intellectual property in your business when expanding to Africa. What can the helpdesk give you? How can we help you actually? You can find training courses such as this webinar. This is just one example, but we have actually planned many other webinars covering different IP landscapes in Africa. You can also find online resources, notably country fact sheets that you can find in our webpage, where you can find information on different IP challenges in different African countries. You can find frequent asked questions where you will find answers to many of your questions if you're thinking about moving to Africa, expanding your business to Africa. And finally, last but not least, you can find a helpline service where we can provide free of charge and exclusively to EU SMEs confidential and tailored advice about intellectual property related questions concerning Africa. But back to our country of interest, which is Kenya today. It's a country that is among the emerging economies in Africa and very attractive for many SMEs. I would like to introduce our experts here. You will see Marius Schneider, that you can see with a bed behind, actually. And it's not because he's just in his room, but Marius is in quarantine. It's in COVID quarantine, but he kindly accepted to come today to this presentation. Thanks a lot, Marius. Marius is the founder and director of IP Africa, a law firm focusing on the protection, management, and enforcement of IP rights all over Africa. He assists clients, including multinationals from Europe and North America, in setting up and enforcing their IP strategy across Africa. Marius is the co-author of the 2020 Oxford University Press publication, Enforcement of Intellectual Property Rights in Africa. This is the first book discussing intellectual property rights enforcement in all 54 African countries. And together with Marius, we can find Nora Hotunam, sorry for the spelling. Nora is a lawyer at IP Africa, together with Marius. She focuses on anti-counterfeiting matters in Africa and has an in-depth knowledge of the law and practice of the enforcement of intellectual property rights. She previously worked in South Africa and the Gambia. So Marius and Nora, the floor is yours.
Yes, thank you very much. Thank you very much for inviting us to this very interesting, webinar. And we are really looking forward to sharing our experience on Kenya with you. We're very excited because Nora is going to fly. She's from the lounge there in Mauritius Airport. She's going to fly to Kenya in a few minutes after the seminar. So that's really quite exciting and interesting circumstances for a webinar. Now, why is it so exciting to speak about Kenya? Because Kenya is really an example in the world, because as far as I know, and to my knowledge, it is the only country that will have very soon a mandatory recordal with customs and the Anti-Counterfeiting Authority there for all imported goods into the country. So I think it's a first, and I think it's really worthwhile that we speak about it, because even in Europe, where we have a very good system of customs enforcement of intellectual property right, we'll touch upon it briefly. Even in Europe, we don't go so far as to make it mandatory to record IP rights with customs and the anti-counterfeiting authorities. So it's really noteworthy. Now, I'd like to give you a brief introduction into Kenya. Kenya is an economic powerhouse of Africa and one of the economic hubs for East Africa. The languages spoken in Kenya are mainly English and Swahili, and there are approximately 50 million consumers and inhabitants in Kenya. So it's a really big country. Nairobi, the capital city, is the largest airport in East Africa, the Kenyatta Airport, International Airport. And Mombasa, which is a coastal city there, is the largest port in East Africa. And it does not only cater the needs of Kenya, but also does provide a transit route for neighboring countries such as Uganda, Rwanda, Burundi, Democratic Republic of Congo, well, the eastern part of it, and the northern part of Tanzania, as well as Somalia. So you already see that these airports and ports are really rather important in the region. Interesting also to note that Kenya is part of the East African Community and COMESA, that is the Common Market of Eastern and Southern Africa. So, lots of opportunities for free trade once the goods are into Kenya. So that is why it's quite important to have a control on what is coming in there. Now, Kenya has a long, let's say, story when it comes to counterfeiting. One of the countries that has learned tough lessons, if I may say so, because if you go back to 1979, 1980, then you will come back in the history of Kenya to what was called the Great Kenyan Coffee Crop Disaster. What had happened, in fact, counterfeit insecticide has been sold on the market in Kenya massively, and that was used to treat a coffee disease. And because it was counterfeit insecticide, as a result, it has wiped out a large part of the Kenyan crop, leading to dramatic losses in Kenya. So this was really, I would say, an awakening process in the Kenyan history, and the first time that they were confronted with counterfeiting, and that they have then taken also, let's say, quite stringent measures, which we will discuss here in a few minutes. The Kenyan Association of Manufacturers estimates that 40% of the sales in Kenya are lost due to counterfeiting. So that's a figure also to keep in mind, even today. And with regards to mobile phones, a market survey determined that approximately 24% of the mobile phones on the market are actually counterfeit. So also an interesting figure. When it comes to medicine, there is a figure from 2011, and according to that, 20 to 25% of the medicine would be falsified within Kenya. So you see quite impressive figures, and so something that one needs to do something about. And we'll discuss in a minute how that's going. Now, before we do so, I'd like to just briefly touch upon the protection of intellectual property rights in Kenya. So you can protect, we're mainly focusing here on trademarks, patents, and copyright. I'll touch a word on other IP rights, but so for trademarks, there is, if I may say so, multi-layer approach. As in many other countries in the world, you can either file a national trademark application to obtain a national trademark registration, or you can designate Kenya under an international trademark application through the Madrid WIPO system. And then you obtain, of course, the equivalent to national rights, but in the bundle of the international trademark registration. So that's, if I may say so, classic, because for Europeans, you will understand that we have the same in most, if not all, European countries. Now, what is there, what does not exist in Europe anymore, I should say, and that are defensive trademarks. Now, what is a defensive trademark? It is a national trademark registration that one can obtain in Kenya, provided the right holder, the trademark owner, has what is called a well-known trademark. That is to say, a trademark with a reputation which has a certain notoriety. Then you can obtain a defensive trademark registration. It is in a special part of the register, and the big advantage is that it does not have to be used in order to maintain valid. So this is, of course, of interest, for example, for luxury companies who don't necessarily use their trademark in all African markets. Now, that's for trademarks. Come to patents. Same thing applies. You can obtain either a national registration for a patent in Kenya. You can also designate Kenya through the PCT, the Patent Cooperation Treaty, and you can also apply under the ARIPO, that is the East African IP organization, which is kind of a mini Madrid and which can provide you rights for a patent under the Harare Protocol in Kenya. Okay, then copyright, also quite important. Kenya is a signatory of the Berne Convention. That means that you can obtain non-registered copyrights in Kenya. And the non-registration, it's important to underline here, does not bar any claim from a author or from a right holder. So that's important. But on the other side, in Kenya, there is the possibility to register copyright under National Rights Registry. We've given you here the website where you can do so as a right holder. So just to keep that in mind, and this National Rights Registry, they have quite important powers when it comes to policing and enforcing copyright infringements.
Good morning, everyone. It's lovely to be with you. So we'll be discussing about Kenya, and if we're going to be talking about counterfeiting, we need to look at the key legislations. What are the legislations that are impacting the protection of intellectual property rights in Kenya? There's a constitution of Kenya. Intellectual property is mentioned explicitly in the constitution of Kenya, so that's very interesting. There's the Industrial Property Act, which is going to look mostly at patent, utility models, industrial designs. Copyright Act, of course, talking about copyright and neighboring rights. Trademark Acts, talking about trademarks, trade name, etc. And the Anti-Counterfeit Act. So the Anti-Counterfeit Act, something we're going to be focusing on quite a lot today, is the law that is used to fight against counterfeiting in Kenya. Kenya is only the second African country after South Africa to have a specific anti-counterfeiting legislation. So that's very innovative of Kenya. And as you will see, and as Merce has already mentioned, that recordal system is also quite innovative. So Kenya is quite innovative in terms of fighting counterfeit goods into its territory. You have the East African Community Customs Management. Maris just mentioned that Kenya forms part of the East African community. And this piece of legislation, the East African Community Customs Management, talks about the customs for the partner state of the East African community. So how does it impact counterfeiting? It's because that law will touch on the international trade of illegal substances and materials, and that includes counterfeiting and substandard goods as well. You got Seeds and Plant Varieties Act, and finally you have a Trade Description Act that prohibits the misdescription of goods, and that includes, for example, giving a false indication of origin. So what we can see in Kenya is that there's a lot of different pieces of legislation that are coming into play when we're talking about counterfeit goods, counterfeit and pirated goods in Kenya. But there's also this very central piece of legislation that is the Anti-Counterfeiting Act, Anti-Counterfeit Act and also the regulations that comes with it.
So then when you are confronted to an IP infringement in Kenya, you can actually choose 3 avenues to defend yourself. You can choose the civil avenue, you can choose the criminal avenue. Criminal avenue has a lot of advantages because it's very deterrent. And you can choose to ask the anti-counterfeiting authorities and the customs as well to assist you in your effort to fight the infringement. Now, let's first look at what is possible under the civil procedure in Kenya when it comes to enforcing intellectual property rights. Well, first and foremost, it is interesting to note that search and seizure orders, our French friends call this la saisie contrefaçon, are available in Kenya. So this is a way of, collecting evidence when it comes to IP infringement. So collecting evidence on who is the perpetrator, what is the scope of the infringement, and the like. So that's quite interesting. Also, injunctions are available. So you can get either temporary or a permanent injunction from a judge. Interesting, I've noted that a temporary injunction is valid only 12 months pending the hearing of the main suit. So that's a particularity, I would say, for Kenya, because in many other countries, this validity is shorter than 12 months for the temporary injunction. Now, in Kenya, as in most other countries of the world, you can also claim damages for an IP infringement. So the perpetrator of the infringement is liable to pay damages, and that includes also the costs of the lawsuit. So that's kind of important. You can ask for the forfeiture and delivery up of the infringing goods for destruction. And you can also ask for information to identify the persons involved in the production and distribution of infringing goods and the channels of distribution. So I would say classic measures that are available in Kenya.
With regard to the criminal procedure, of course, the police is allowed to go and search and seize a goods. Anti-Counterfeiting Authority definitely have this authority to enter into premises and to seize goods that they presume to be counterfeit, that is suspect of being counterfeit. If someone is found guilty under criminal proceedings, the law provides for fines and or imprisonment. Also interesting, there's a few laws where you will see that upon a second conviction, the fine and the imprisonment is going to be harsher than on the first conviction. So really creating that deterrent effect for someone to repeat the same offense. There's also injunctions, and finally there's forfeiture. Forfeiture, for example, where the goods may be forfeited to the state so that the goods may be destroyed. So as Marissa just said, very classic examples of classic remedies that are available in Kenya, but quite interesting to see that there are quite a few of them, and that they're all meant to help the right holder uphold their rights.
Exactly. And what I think is important to outline, 2 things, is that this is only the, let's say, IP legislation that allows these criminal measures. Of course, if counterfeit products are also infringing on another legislation, like, for example, pharmaceuticals, there are other and even more severe penalties that are available. So this is just the generic, let's say, IP legislation. And also what I think we want to highlight here is really don't neglect this criminal avenue when it comes to enforcing intellectual property rights. Why? Because it is very deterrent. There are fines, there are sometimes prison sentences that are handed down by the courts. And also it may lead to inelectability, so people can no longer carry out public mandates and stand for elections. So, I think this is very much of a deterrent, which we recommend to take into account. And we have, together with our local colleagues in Kenya, quite a few criminal proceedings ongoing there, and which have led to significant criminal condemnations. In our case, most of these matters do involve counterfeit pharmaceuticals. So it is something that is really, really taken very serious. So that just to conclude on the criminal enforcement aspects. Then I have already said, the Anti-Counterfeiting Authority is, as well as customs, are both also an avenue that is to be taken into account when it comes to IP enforcement. So customs, as well as the Anti-Counterfeiting Authority, have the power to receive an application for customs action against infringing imports, but as well exports, transit, if I'm not mistaken, Nora. The application can be filed by a trademark owner, a copyright owner, patent owner, but also owner of a design patent and a plant breeder's rights, to the Commissioner of Customs and or the Director of the Anti-Counterfeiting Authorities. What are the requirements? The requirements is to produce a sample or a photograph of the product, as well as proof of ownership and continued validity of the intellectual property right.
So once you've forwarded all the documents needed to either the ACA or customs, you should have a written response within 3 working days. So the response can be either yes. Usually if you've provided all the documentation, then it is automatically a yes. And if they say no, then they have to, maybe there's a piece of document missing or there's a very specific reason, then they will have to provide you with the reasons as to why they're refusing your application, which is good. Then it allows you to repair any defect in your application, and maybe you can reapply again as well. So the validity period may not exceed the validity of the right. So what that means is, for example, simply if your trademark is going to expire in 4 months, well, they can't give you they can't afford you a protection that's going to last more than 4 months. So it can only go as far as your right is valid. Now, what will happen? So now you've got your positive response. What is going to happen? Well, either customs officers or an inspector of the ACA will seize and detain the suspected goods, that is, the goods that are suspected of being counterfeit or pirated goods. So there must be within the next 3 months a criminal charge. So maybe if you manage, you can find, if you are able to find an amicable settlement before the 3 months, then that's perfectly fine. But if there's nothing, you need to file that criminal charge within the 3 months. Why? Because if you don't file a charge within 3 months of the goods having been detained by either customs or the ACA, well, the goods should be released back. So the criminal charge is very important. Once there is a criminal charge, and so the case will go before the court. If the court finds the importer guilty, there will be either fine and or an imprisonment. If the goods are found to be counterfeit, the goods will be destroyed. And if the import and the destruction will be at the cost of the importer. If we cannot find the importer has completely disappeared, because sometimes it does happen in those cases that the importer can no longer be found, then the goods will be forfeited to the state for destruction. That is, the goods won't be recycled or reused, or they are being forfeited for the purpose of destruction by the state.
Okay, so thank you. That was very interesting. I mean, what is interesting is that from our experience, actually, the authorities kind of like the idea that the right holder sits down with the infringer, tries to find an amicable settlement. I mean, we had several cases where we were encouraged. We only represent right holders, never infringers. So where our clients were encouraged to sit down and negotiate with the infringer to, try and find an amicable settlement. So And I guess that's why also there is this 3 months term, because as you know, in Europe, when there is a customs detention, this detention can last up to a maximum of 20 working days. So that's de facto more or less a month, if you calculate the weekends, so 20 working days. Whereas here it's 3 months, which is significantly longer. So I guess that's the explanation, but I just wanted to highlight, this, quite important difference compared to what is the case in Europe. Also, important, noteworthy, ex officio actions are possible both by customs and the Anti-Counterfeiting Authority. Then the same procedure applies. Action has to be taken by the right holder within the 3 months to further to the detention. And also important, the inspectors of the Anti-Counterfeiting Authorities, they can act inland. So on the national market, they can undertake action. So it's a little bit comparable to what we know in many European countries from the trading standards authorities. In Belgium, for example, we have the economic inspection who has these powers. Back in the time when UK was still a member state, they had the trading standards. In France, it's customs that are competent on the national market. So likewise in Kenya, there is a possibility for the ACA inspectors to take action. And yeah, now, Nora, we come to something really very special and very Kenyan.
That is true. So we're going to be talking about the compulsory recordal. What is a compulsory recordal? It means that as of 1st July 2022, so that's not very far, IPR of all goods that are imported in Kenya must be recorded with the ACA. So that means that every single goods that is imported that bears a trademark, bears a copyright, must be recorded with the ACA. So it's very special because we have looked a bit everywhere. We have looked elsewhere to see if any other country has done this. We haven't found. I mean, if anyone knows of a country that has a similar experience, we'll actually be very happy to learn, to know about it, to learn about it. And if anyone also has a retour d'expérience, like if you can give us how it worked, if you have encountered something similar and you want to discuss how it worked in your country as well, we'd be very interested to know more about it as well. So we are guessing that the procedure that we've mentioned before is most probably not going to be used very much anymore, because most right holders will compulsorily be now recorded with the ACA, and therefore most right holders will be counting on the ACA, if I may say so, to undertake to look after any suspicious goods coming in, any counterfeit goods coming into Kenya. So by compulsory, it very much means that it will be an offense in Kenya to import goods whose IPR have not been recorded with the ACA. So the aim behind that compulsory recordal is to create a database of IPR information that's going to be visible to the ACA inspectors and also over law enforcement officers such as customs. And I think this very much responds to a demand that we've seen with a lot of customs officials in a lot of different countries, where they say, we're being asked to stop counterfeit goods, but we don't have the necessary information to know whether they're counterfeit. We don't know who to contact. Sometimes we see things, but they don't know how to contact. So therefore, it becomes too complicated for them to actually take any action. And it is very true that through a compulsory recordal, you're at least solving that first issue of customs officials saying, I can't know if these are really counterfeit goods or not. I don't know who to contact if I'm seeing any counterfeit goods. So that's really the first step that this problem is solving. And ultimately, what the Kenyan state, the Kenyan government, the ACA is going to try to do is to try to have a certification mark. That's going to be an anti-counterfeit device that's going to be put on all imported goods in Kenya. So every single imported goods going to bear that certification mark. And if you have an imported good that don't have a certification mark, then that good shall be destroyed and seized. So that is not the case actually at the moment. That's part of, I may say, future growth plan of the ACA and of how that compulsory recorder is going to work. But for the moment, we're simply recording all the IPR of the goods. And of course, as you can imagine, that's concerning quite a number of right holders, because Kenya, as Maris mentioned, is a huge market. So we have quite a lot of inquiries from our clients, from right holders, who are asking, how is this going to work? What documents we must provide. So I think Maris now is going to be speaking about what you need to provide to do the compulsory recorder.
Yes, so thank you. So it's quite important that the right holder provides details on who owns the rights and who can be, of course, also contacted in case there is an infringement. The right holder will also have to provide certified copies of its intellectual property rights that are subject to the application with customs and the ACA. Also, and that's, I think it's not mandatory, but details on foreign persons and business entities that are authorized or licensed to use the IP right in Kenya. The right holder will also have to submit samples and photographs of the protected goods, a detailed description of the goods, and details on who does manufacture the goods. And last but not least, the application has to be accompanied by the prescribed fees.
So for foreign owners, that is right holders that are not based in Kenya, then you need to have a Kenyan agent that's going to represent you with the ACA and it's going to proceed with the recorder. So how it's going to work, Maris stated, there's a list of requirements of information. That's not all the information, is quite an extensive list, but we're just putting a few of the most important one for you. Well, you've got, once you collect all the information and you applied for the compulsory recorder, the application will be processed within 30 days. And once it's approved, it's going to be published in the ACA newsletter. So that recorder is only going to be valid for a period of 1 year from the date of its approval, or the validity of the registered IPR. As I mentioned before, it will only be as long as your trademark is valid, or a year from approval, date of approval. It's only valid a year, which means that every year right owners will have to renew their recorder with the ACA, and or again, this time, this is going to be subject to the payment of a fee.
Mm-hmm. Okay, so it's interesting what you said, right? The fact that our right is recorded will be published in the ACA newsletter, so third parties have access to this information. That's something, you know, that we don't really know like that in Europe. In Europe, there's no register of application for customs actions that are filed. It's you know, information that's kept confidential. So it's interesting here to see that it's you know, publicly available in Kenya, as for example in Mauritius. It's not the only country, Kenya, to do it like this. Now that can of course trigger quite a legitimate question, which is, well, is the absence of a recorder with the ACA also evidence, or at least the beginning of evidence, that an intellectual property right is not used? For example, could this be used in cancellation proceedings against a trademark by saying, you know, you didn't register your trademark with ACA, means that you don't use it in Kenya, so I you know, win my cancellation action? It's quite an interesting thought, and we have looked into that question for clients, and it appears that it can be used as an argument, but of course it will not be as such sufficient, you know. But it's a good, let's say, starting point. So really, right holders should be, if I may say so, a little bit wary about this. So this is to conclude the compulsory recorder, the Kenyan, let's say, you know, unique way of approaching things. So that's good. Now, we would like to, at the express request of the IPR help desk, we would like to have a quick look at what happens to counterfeit goods that are destined to Kenya that would be transiting through the EU. I think it is really important to remind right holders in the European Union that if they have an EU trademark or a trademark registered in one of the EU member states, they do now have the opportunity to take action and measures with the help of customs against counterfeit goods in transit, even if these goods are not intended to be sold on the European market. So there is the possibility now in Europe to take action against these goods in transit. So let me give you an example. That would be, for example, the case for counterfeit car spare parts that are produced in China and that do transit, for example, through Germany to go then to Kenya. Why would somebody do that? Why would somebody, an infringer, carry counterfeit car spare parts through Germany to bring them into Africa? Well, the answer is easy, because then in the country of destination, that is to say Kenya, these goods will be arriving as goods originating from Germany, the EU. And for car spare parts, for example, for German cars, Mercedes car spare parts, it would look rather legitimate and it would kind of give them a flair of authenticity if instead of coming from China, where they're really produced, they come through Europe to Kenya. So this is just a reminder for right holders that in such a situation, they can take action against these counterfeit products in the European Union. It will be necessary for the right holder to prove during the infringement proceedings that the right holder can also prohibit the sale of the goods in the country of final destination. There may be some discussion on that, but I would say that most multinational brands, like, for example, in our example, go back to our example, the car spare parts, this trademark will most likely be protected in the country of destination, that is to say, such an important country as Kenya. So that is a point we wanted to make. And then before we take your questions, I think we would just like to run through a few basic tips and tricks, which we have for all African countries, by the way. So Nora.
Yes, so first tips and trick is to follow the trade of goods. As you mentioned, Maris mentioned in the beginning, Kenya, it's a big market, but it's also the point of entry for other countries. We're talking about South Sudan, we're talking of Uganda, we're talking of Rwanda, etc. So if, for example, as a right holder, you notice there are counterfeit goods that are in transit in Kenya, and for a reason or another, you're not able to stop them, then you might want to see where is its destination country. So really the idea being that if you can't act in one country, follow the goods, because you might be able to act in the other country.
Okay. And second tip we would like to give you is to cooperate always with local authorities. Build up good relations with them. It's important, for example, that you participate in customs trainings, police trainings, that you and or your lawyers on the ground do forge really these personal contacts with the authorities, and that will help you to get actual results, because a lot of this, enforcement game, if I may say so, is about confidence and personal links with the authorities. So use the authorities. Keep in mind that there's not only customs, police, the Anti-Counterfeiting Authority, there may also be Food and Drugs Administration, Standards Administration, and so forth, who will be able to help you. So exploit these relations and contacts.
We always advise our client to register defensive trademarks. Defensive trademarks are available in Kenya, so make good use of them. If you're a well-known trademark and you're not trading in Kenya, or you won't be sure, and you don't want to be facing a non-use action at a later stage, You can even use your defensive trademark as a proof of being a well-known trademark in any other case before the IPO or the courts, for example. So it has a lot of different uses, and it's very, I mean, it should be something that if you're a well-known trademark, you tend to do. And defensive trademarks, another country where you can also have a defensive trademark, that's just a little à côté, it's Nigeria. I mean, another country, another big important and economic powerhouse of Africa is Nigeria. So in those two countries, we very often advise our clients to register defensive trademarks just to be sure that they're protecting the best way they can their trademarks.
Okay, so then sometimes in Africa, you may end up in a bit of a deadlock situation. I'm thinking in particular of African countries where the authorities do request right holders to, let's say, actively participate in the enforcement effort. There are countries in Africa where the authorities say, look, as long as you don't fund our actions, we will not be able to do anything for you, because they lack resources. Now, for Western right holders, this is most of the time a no-go. So you will arrive in a bit of a deadlock situation where the authorities say, well, we are happy to help you, but you need to, fund the action. Right holders say we cannot do that. Then it's a difficult situation. In this kind of situation, what we do recommend is to engage diplomatic channels. Don't forget, the EU has a delegation in most African countries. Also, nations have, France, Germany, the United States have diplomatic missions in most African countries. And oftentimes there is an IP attaché in these countries. So really never hesitate to contact these diplomatic missions to assist you if ever, you encounter certain difficulties. That's our practical recommendation.
We advise people to rely on local eyes and ears. And this is particularly true. I mean, this is an advice that very much focuses on right holders. It is important to have someone in the country that is keeping an eye on what is happening in the country on this. Are there a lot of counterfeit goods in the country? Is there a specific area in the country? Is there a specific market in the country where most of your counterfeit goods are? These information often will only be available to people that are in the country. And it's very important as a right holder to create a mechanism where those that are on the ground, whether it's the distributors, whether it's your own employees, they're able to, it's an easy channel for them to pass their concerns, because sometimes they might see something, you have a distributor, he might see something, but he doesn't know who to contact at the right holder's office to relay his concerns. So just have in place a mechanism where it's very easy and it's very clear who you must contact if you find any counterfeit goods. And this will really help you as a right holder be aware of what is happening on the local markets.
Okay, and last but not least, I'm going to say that's a bit of a publicity for your own business. Well, we always recommend to hire a lawyer, if you don't get along yourself as a right holder. I think that's, our recommendation. So this concludes our little presentation. We thank you very much for your interest and for participating. And Esther, we are, of course, open to take questions from the floor.
Thanks a lot, Marius, and thanks a lot, Nora, for this very comprehensive presentation. Marius and Nora, one question. On trademark registration, when we speak about trademark registration, is it the same as a recorder? Is it similar?
Yes. So, sorry, when we're talking about trademark registration, yes, that's a recordal process. So you have to apply for the trademark application either directly in Kenya for the national application or through an international application. And interestingly, in Kenya, it will take approximately the same time as in the EU IPO to get a trademark registration. So Kenya is quite a quick country. They slowed down a little bit with the corona pandemic, but it is really kind of one of the quick countries in Africa where you can get trademark registration quite quickly.
If I may add on what Marissa just said, so you can very easily get a trademark, but you mustn't confuse, but it's important right holders don't confuse trademark registration with a trademark recordal at the ACA. These are two very distinct processes. Like you do have to register your trademark, and that you're going to do either by IP, as Maris mentioned, or you're going to do it through Madrid, but you also have to record it with the ACA. So that's like, it's so right holders in a way have two things to do in Kenya now. They have to register their trademark and they have to record their trademark with the ACA. So that's two different things we need to do. And they'll also have to renew their recordal, the ACA every year compared to the trademark every 10 years.
Thanks a lot. I see one raised hand from Eileen. Eileen, you are invited to ask your question. You can unmute your microphone.
Thank
and your
you.
camera as well, if you want.
Good morning. So my question is, okay, I'm an advocate in Kenya and I practice IP. There is this issue of where we currently have a lot of counterfeit goods already in the market. So I am wondering, moving forward, now that we have this recordation law being implemented, how do we, or rather, how do our clients go about assessing what is already in the market vis-a-vis what they are hoping to curb as we're implementing this new law? Because this is a question we have received in our office from some few clients. They would like us to do a sort of like market survey of what is already on the ground in terms of counterfeit, but it becomes a bit complicated because you have to do sort of like a training with your original products vis-a-vis what is on the ground, and then it's just it feels like a messy situation. So what would you recommend to be the most ideal situation under the circumstances? Thank you.
Yes. I think, to be honest, there is no other way than to go about and go out on the market and identify for yourself, if I may say so, as a right holder, what is exactly going on, what's the scope of the counterfeit products, what type of products are around. That's what Nora said a little bit, I think so. I mean, it means that you have to really use your local eyes and ears to identify the problem. There's no way around that. That's everywhere in the world. It's the same. It's the same in Europe, in North America. Of course, the prevalence of counterfeiting is less high, I guess, in these markets, Europe, North America. But, nevertheless, right holders will have to train people to go on the ground. Now, you can do that in two ways. Either you rely on investigators. So, Eileen, in your law firm, you could train investigators who then go out, or your lawyers even, paralegals, who go out on the market and identify these counterfeiting hotspots and make a bit of an inventory. And then, of course, you can give that in a second step to the authorities so that they, take the necessary action. Or your clients can do that themselves. I would think that actually many companies do have an office in Kenya. I think that's the good news about Kenya. Many, let's say, mid-sized European companies would have an office or a distributor in Nigeria whom they could send out to check the situation on the local market. And okay, as I said, once you've mapped the situation there, you can then ask the authorities to come in and take the necessary let's say, actions. Nora, do you want to add something?
Just want to say, it is very true. That's going to be quite a lot of things to do for the ACA. I mean, they do have that power to act inland. Now they're going to be doing the recordal. That's quite a lot. And I mean, it's not just a few recordals as it is usually in, for example, in Mauritius, or I guess even in Europe, where you have a few companies that have decided to record the trademark. Here, you're going to have every single imported brand in Kenya that is going to be under that recorder. So that's quite a lot of work. And it's true, as Maris has said, I think the important part is that you find out about the counterfeit goods. I think if they're going to be having it's quite a lot of work for them. And the best way, and this we found also as well in our work outside of Kenya, is that when you provide authorities with as much information as possible. That is, that they are not going on a fishing mission, but you are telling them this is where the counterfeits are. This is the type of goods that are being counterfeited. This is what the original products give them. You're more likely to get results, and you're more likely to get results quickly, rather than telling them, okay, in this market, there are counterfeit goods, and just sending them out there to go and look at every single stall. It's much more difficult. I mean, at this stage, rather give them the most information possible, so that they can do their work at the best they can.
Thanks a lot, Nora. I am looking at the chat. I don't see any further questions, so I will go for the question that can be of common interest for everyone. Can the anti-counterfeiting authorities and customs act against small consignments?
If I may take that question, do you mind, Esther?
Perfect.
Yes. So the ACA and customs, they will not act against small consignments when those goods are meant to be used for domestic and personal use. So it is like if someone has brought like a T-shirt or two of counterfeit T-shirts to wear. However, there could be small consignments that are destined for trade. It's not personal use. It's just that the person is bringing into Kenya counterfeit goods little by little. In that case, those small consignments that are meant for trade, they can be seized by the ACA and customs.
Good. So maybe I can go for a last question that can be of common interest, which is about are out of court settlement following action by the Anti-Counterfeiting Authorities possible?
May I also answer
Please
this
go
one?
ahead, Nora.
Yes, so the ACA, the executive authority, has arbitration power, and if both parties are agreeable, that is, both the complainant and the accused, the executive director can order the payment, for example, of a fine committed under the ACA. So it is possible to have an out-of-court settlement with the executive director being the arbitrator in certain ways. And of course, that's very useful because, I mean, it allows you not to go in court. Of course, that's going to be much faster if you went to court. So for a lot of right holders, it is something that could be of benefit, that can be of benefit to them, but they could be interested in is just go through the ACA rather than going to courts where a resolution is going to be much later on. But I think you have a question for you, Esther, in the chat box.
Yes, actually, there's a question about AFRIP, the responsibilities of AFRIP. So AFRIP is a project, the helpdesk is actually included within AFRIP, which is a project that is co-funded by the European Commission and the EU IPO in Alicante, and which aims to increase effectively the level of intellectual property rights in Africa. So it has many activities. One of these activities is the Africa IP SME Helpdesk, but we have many other activities. And I really strongly invite you to actually go into the webpage to look at our activities and ask any specific question that you will have on the specific project or on the help desk. So I think I hope that this can answer slightly your question, and I invite you to actually go further on questions if you want after looking at our webpage and if you have any specific doubts about it. I think that it's already 11, so I will make an end to this webinar right now. Thanking a lot the two speakers for the different explanations that were very comprehensive on IP doubts that you can have as an SME while expanding to Kenya, or different ideas that you can have on IP while you're working already in Kenya in an SME or a business. Thanks a lot to the participants, of course, for their questions. If you have more questions, please don't hesitate to go to our web, to send us messages. We are very happy to actually answer to any question. We invite you strongly to go to our social media as well. We are on Twitter, we are on Facebook. So please go and watch our social media. And with this, I would like to wish you a very nice day, end of the day, and hope to see you very soon in one of our next webinars. Thanks a lot.